Good evening, everyone. There's still a few seats over here if anybody is interested. Welcome to Politics and Prose. I'm Brad Graham, the co-owner of the bookstore, along with my wife, Lissa Muscatine, and it's a real pleasure for both of us to be hosting law professor Harold Koh, who's here to talk about his new book, The National Security Constitution in the 21st Century. Lissa's going to say something, and then I'll be back with more.
So this is what happens when we have somebody we really love and adore come to speak at Politics and Prose, and we argue over who gets to do the introduction. And so Harold is definitely in that category. So I told Brad if he was doing the introduction, I at least wanted to say something. And what I wanted to say is that, it's obviously an honor and a privilege to have somebody of his expertise and his commitment to human rights and other issues that we all care about here at PNP. But it's also just so special because we really truly do not just admire him, but adore him. And I first met Harold 1994, I think, in the Clinton administration. And then we served together again in the State Department, in the Obama administration, and we've crossed paths and have many overlapping universes that have deepened over the years. I also want to say his wife, Christy, is here somewhere. Oh, there she is. And is your daughter, Emily, here, coming? Oh, right next to you. Okay, I didn't have to look far. So thank you also for being here. And we have other family connections to Harold that Brad will mention in a minute. But mostly, Harold, we are really just so excited to have you. We're so excited for this book, and we just appreciate how much you have done for so many good causes for so very long, and always cheerfully. Have you noticed that? Like, Harold is just, despite the tumult around us, he remains sort of a cheerful warrior. So thank you very, very much.
Okay, yeah. So he is a brilliant and engaging guy. For those of you who don't know, he's at a school, Yale Law, that has more than its share of such types, brilliant and engaging. But Harold still stands out there as one of the country's leading experts in public and private international law and national security law and human rights. He first began teaching at Yale in 1985. And for 5 years in the 2000s, he served as the law school's dean. He also served several stints in government, one at the Justice Department before coming to Yale, and 3 at the State Department while on leave from Yale. He just goes back and forth and back and forth. So here's one thing to know about Harold's approach to teaching. In recent years, he's made it a point to get to know all the more than 130 students in his class at the start of school each year. He meets one-on-one with each student for about 20 or 30 minutes, which enables him to learn about them and makes the students feel genuinely appreciated. At least that's how our daughter felt when she took his class a few years ago. She's here this evening, sitting over there. So Harold, remember, she knows all your favorite stories and is prepared to fact check you. Harold's authored or co-authored 9 previous books and published, more than 200 articles. His new book is actually a revised and substantially expanded version of his landmark 1990 work. Back then, Harold coined the term National Security Constitution, right? That was your term, yeah. Which refers to the U.S. constitutional norms that are supposed to govern the conduct of national security policy. Those norms call for a sharing of power among the President, Congress, and the courts. But as Harold discusses in his book, the norms have eroded in recent decades. Presidential power has grown, while all too often Congress has tended to acquiesce, and the courts have either deferred or rubber stamped. So instead of a balanced institutional participation in national security decision-making, there's been a tilt toward executive unilateralism. And in his book, Harold clearly and authoritatively examines why this has happened, the dangers posed by this distorted situation, and what can be done to restore balance to the system. Now, in conversation with Harold will be a journalist who himself knows a thing or two about national security affairs, Charlie Savage, who covers national security and legal policy issues for the New York Times. Charlie arrived at the Times in 2008 after stints with the Miami Herald and Boston Globe, and after winning a Pulitzer in 2007 for his reporting on presidential signing statements. His first book, Takeover, also came out in 2007 and was about the Bush administration's efforts to expand presidential power after the 9/11 attacks. His second book, Power Wars, was published in 2015 and examined the Obama administration's national security policymaking on such issues as drones, detentions, surveillance, and leak investigations, all that fun stuff. So he's a great person to have in conversation with Harold. Please join me in welcoming Harold Koh and Charlie Savage.
All right, well, thank you everyone for coming out tonight. That was a great introduction. I'd like to introduce Harold in another way. I got to know him as one of his students in 2002. I'm sure that a lot of people in this room are also his student in international human rights class or perhaps civil procedure. And then because of his role in both challenging government policy and then helping shape it alternately, he has been a figure in my professional life ever since. He's an extraordinary person, an unusually interesting person. You just got a taste of it, but let me go a little deeper and remark upon how unusual it is to have someone who is a true scholar, a tenured professor at Yale Law School, dean for a time there, true academic, but also a true government operative lawyer in 4 administrations over the last 5 decades, toggling back and forth, as you said, between these 2 roles. And I don't think there's anyone else who has that level of deep experience in both simultaneously. You have occasionally a professor who sort of moonlights in the government a little bit, or you have someone who's a longtime government lawyer who kind of ends up in a sinecure at a law school teaching, but is not really a scholar. Harold is truly both, and that has made him an unusually interesting person in both dimensions. I wrote in my book, Power Wars, about how he was among all the high-powered national security lawyers in the Obama administration struggling with their war on terror, the inheritance they had picked up from the Bush-Cheney administration, what they were trying to do with it while also trying to, continue to wage a war on terror within what they saw as the rule of law. All kinds of major fights and deliberations within that administration, more than any other of the senior lawyers there. Harold was the one who was the most rooted in trying to advance a view of human rights, civil liberties, and not just adherence to the formal strictures of the law. And he was quite willing to break some eggs and make some omelets to achieve that. And if I maybe relished being a bit of a shit disturber from time to time in the government, and taking heat from it and making some enemies and not minding if he did. And at the same time, because he was in part of an administration that was actually dealing with the world as it is from a position of responsibility, when there really were people out there trying to kill Americans, plotting from lawless badlands where there were no U.S. troops on the ground and also no local police force that could go arrest someone, raising the question of, for example, whether the United States should use drones for targeted killing operations. He was participating in those decisions, trying to shape them to fit human rights law from, as he saw it, from behind the scenes, but also defending the administration's actions in public and to some extent becoming the face of the proposition that what Obama was doing was lawful. And that back in the academy, that made him get flack from the left as someone who was, as some purists from the faculty lounge saw it, betraying the sort of hands can't ever be dirty in the stance that a academic who purely is involved in theory and high principle and not the practical realities of governance maybe freer to indulge in. And so in both arenas, as a practical government operative in the academy and as a true scholar interested in high principle and what is the big picture of what we're doing here as we try to solve this mess in front of us in the government operations, he stood apart and stands apart. And now he's written this book. He calls it an updating of his 1990 book, but I've read them both. It's a almost completely different book. You know, that book, it culminates in the Iran-Contra affair. He was a young man, had not experienced much about the world yet, been in the OLC, the Reagan administration. Maybe you were 30 or so when you were working on that book. He's experienced a lifetime since then, and society has experienced enormous change since the 80s, which obviously no one here needs to be reminded of. Now he's come back to writing a book that is a very odd book, a very interesting book, a fascinating book. It is at once, I've had the opportunity to read it. I'm sure all of you are going to buy it tonight and we'll read it starting this weekend. You'll see that it's several books at once. It is a history of national security and foreign policy making fights in the United States from the founding to the present day through a legal lens, just descriptively. It is a professional memoir of the slice of his life that has interacted with these issues and some of the roles he personally played and witnessed. And it is also a normative argument where he diagnoses what he thinks has gone wrong about how the country is working in this space and offers some prescriptions of maybe how we can get back on track as he sees it. All of this interwoven together. So it is a great book. It is a fascinating book. There's not really another book like it that I'm aware of. I'm glad you wrote it. I wish you'd written it in a way a long time ago for someone like me to get up to speed more quickly. But it was a pleasure to read. And so let's get into now what you're trying to do. And the introduction hit this a little bit, but maybe to lay the groundwork, can you talk just briefly at a high level, what do you mean by the term national security constitution, and what is the fundamental argument you're making in this book?
So when you study constitutional law as a college student or graduate student or law student, you think about the Supreme Court. But there is, in fact, a subset of constitutional law which is devoted to foreign policy and national security policy. And it's an interesting collection of a few Supreme Court cases, but mostly executive and congressional practice, executive orders, and other things that forge a package of norms that govern the way in which foreign policy is conducted. And very early on, when I came down to Washington, now 46 years ago, I started to realize that nobody really understood how this body of law was made or what it is. So the part of the first book was simply to coin the phrase, the National Security Constitution. They didn't want to put that in the title. They said nobody had heard of it, and I said, well, nobody had heard of the welfare state either. so anyway, at least now people understand the term. But there are really in this book, as you say, Charlie, three different stories. There are many I could talk about. The first is the story of the nation. And it's very simple. If you ask a school kid what is the basic principle of the Constitution, they say checks and balances. Do checks and balances apply when foreign policy is at stake? No. In fact, the way that it's evolved, the system of checks and balances has atrophied so that almost everything is on the president. Congress is avoided and detoured around, and the courts generally defer or rubber stamp. And so, in fact, we have two competing paradigms of how constitutional law is supposed to function. One is what I call balanced institutional participation, as typified by the Youngstown sheet and tube tripartite framework of Justice Jackson. But the alternative is set forth in a Supreme Court opinion called U.S. versus Curtis Wright Export Corporation, which in 1982 I learned in the U.S. government is called the Curtis Wright, so I'm right site. So if the executive branch is doing something, the Justice Department cites Curtis Wright, Passim, and then claims that it justifies everything that they do. So part one of the book is just to trace the struggle between these two paradigms from the beginning of the Republic to the present. I've coined the phrase for this, the eras tour. You know, American infancy, regional power, American hegemony, the Cold War, post-Cold War, the age of terrorism, you know, Bush and then Obama. And then the current period, the age of globalization, Trump, Biden, and then who knows what's next, Trump or Biden. And, you know, what I basically argue is that in this period, the trend has been toward unilateralism. That some administrations like Trump or Bush are proactively unilateralist. The president grabs power, claims a constitutional prerogative, Congress defers, and the courts rubber stamp. And in others, like the Biden and Obama administrations, the president wants to be more restrained, but in fact has to be reactively unilateralist if they're going to get anything done. And so we have this strange phenomenon where the pendulum keeps moving toward unilateralism, either proactively or reactively. And increasingly, the president is a victim as much as he is a villain. Now, this, something happened last night. I wasn't actually paying attention because I was getting ready for the book talk, but it set forth, I'm sure, in all of you, the question of what would be the difference, depending on who gets elected in November. Well, interestingly, because these two people have been president before, we know that Trump will be the most aggressively unilateralist Curtis Wright president in American history. He said, Article 2 lets me do whatever I want. And as proof of what he did, he used it for a Muslim ban, punitive immigration policies, building a wall, to impose trade sanctions on China. He talked about this again last night, weaponize the Justice Department, and in all respects act, you know, without meaningful oversight by either Congress or the courts. But think about it that, and he actually showed that this could be taken well beyond anything that any of us ever imagined. That, you know, if he's challenged by Congress for subpoenas, he'll litigate them, and you don't get anywhere. If held responsible in the courts, he'll claim immunity. If there are investigations, he'll say they're unconstitutional, or he'll pardon or grant clemency to the defendants. In fact, he announced again last night that that's what he was intending to do. Even after he's out of office, he'll take the classified documents he wants home and use them for his own purposes. And then, most fundamentally, that he can use this power to try to interfere with elections, either by himself or with the aid of a foreign country, and say that anyone who is pursued for that is themselves a patriot and to be pardoned. The important thing to see is not just that this is what he intends to do, but that he thinks it is what the Constitution permits and requires. He says that any challenge to him from within the executive branch will violate the principle of the unitary executive, and any challenge coming from outside the executive branch will be an unconstitutional separation of powers, which means that the president can nullify the rule of law for his own administration in foreign affairs. And it also means that the president can himself become a national security threat. And this is ironic, since the evolution of unilateralism was so that the president could protect us from unilateralist threats. Well, what about Biden? What if Biden is elected, which is certainly what I hope. He's a good and decent man. And friends of mine who are here today are working in his administration. Still, there is no expectation that Congress is going to be a real partner or that the courts are going to be constructive players on foreign policy. When I returned to the Biden administration in 2021, it was as if one muscle had been given steroids for 20 years. The military and intelligence parts of the government were so wildly out of shape, and the diplomatic and justice components were shrunken in their influence and outvoted on every conceivable ground, out-resourced, et cetera. And so we have increasing centralization in the executive branch, increasing centralization in the White House and in the National Security Council. Congress is, rarely productive and ends up being paralyzed or unconstructive. What it can do is block executive confirmations and block treaties, as a result of which those who do operate in unconfirmed positions have little loyalty to Congress or a little desire to work with them. And then we have a Supreme Court, which in the 21st century has gone wildly nationalist in the name of originalism, even though the whole originalist idea was that the Supreme Court would reconcile what the US law is with the law of the world. John Marshall had many, many more opinions about international law than he did about US law because there was no US law. And they cited foreign law all the time. And we now have a situation where, Brett Kavanaugh, for example, says, I believe in the American rule of law. He was my student, so I guess I'm not a very good teacher. But the American rule of law, what about the rule of law more generally? And he says, they say you cannot borrow from foreign law in trying to understand how to structure a constitutional solution or a policy outcome. To me, this is amazing. Americans are borrowers. As I say, when I go to my taco truck, I say, will you put a little kimchi in the taco? That's what we do. Americans borrow from foreign governments. And they say, don't borrow, don't look. Even though borrowing is as American as Apfelkuchen or Der Frankfurter. And interestingly, 12 of the justices, including Alito, Gorsuch, and Kavanaugh, have cited foreign precedents when it serves their own purpose. For example, in the Dobbs case. So this is a historical story that I think has reached a crisis point, and it will only get worse if we don't accept that it's a problem. The other two stories I'll just say more quickly. I've worked on this book for 37 years. My daughter Emily is here. When it began, she was a toddler singing Disney tunes, and now she works at the White House. So that tells you something. I finished the book in 1990. Folks like Charlie read it. But at the time, I always wanted to redo it. And I thought sometime before I'm done, I'll do that. And 2 years ago, after I left the government and went to Oxford on sabbatical, I thought, if I don't do it now, I'll never do it. But in the process of doing it, I started to realize I had served in, as Charlie said, 4 governments in 5 decades. I had been an executive myself as dean of a law school and head of various bureaus. I had sued the government multiple times. I had represented foreign governments in international tribunals, and I had spent many, many hours talking to judges and legislators. So I saw the world a little bit differently. Finally, I think the story of the book is about the ethical story, the role of lawyers and the role that lawyers play in reconciling our rule of law obligations in the domestic and the international space. Very few of these cases get to courts. And so whatever reconciliation is going to happen is by opinions written by government lawyers. And we have famous examples of disastrous performance there, the torture opinions, the black sites. And then the question is, when you are working on something like drones or Guantanamo or the Libya intervention, when are you actually serving the law and when are you in fact violating the law? And that's an ethical struggle that's very difficult for somebody in the government. In academia, if you make a mistake in the faculty lounge, you go get another cookie. You know, in the real world, if you make a legal error like this, you know, with Libya, 10,000 civilians could die. And then the question is, who's your audience to do this? So those were the stories I tried to tell. And I guess the last point is this. Charlie, when I wrote the first book, I thought I would live forever. I really did. Now I think it's a little bit less likely than I did then. And I thought, what have I learned? What are the lessons that I would like to present to students and readers so that our children and our grandchildren have a better 21st century and 22nd century than the ones that we've lived through? And recent times have been very bleak in this respect, and I worry. And my thought is, we have an issue. It's a problem. It's not just personalities, it's structural. We need structural solutions, and somebody should put down what they think those structural solutions are. The alternatives are acceptance, which I'm not going to do, despair, which I'm not going to do, reform now, which may not happen because of political stalemate or dysfunction, and reform later, if people remember to be Americans first. And so what I have here is a mosaic of recommendations at the end of the book that are designed to give people ideas for things they can implement over many years to get us to a better place.
Well, that covered a lot. I wrote the question briefly to set the stage, but no, that's great. So let me jump ahead then, because we're going to want to get some audience questions as well. I reflected upon reading this book over the last week, and upon knowing you and writing about your struggles within the Obama administration in particular, on what I see as a kind of a tension in your worldview or your work that is reflected here, but was also reflected in the fights you were having back then. And to try to articulate it, it's about process and it's about right substance and or the policy outcomes you think are the right policy outcomes. When you describe the National Security Constitution, it sounds very procedural. We want all three branches to be involved in shaping these decisions. We don't want unilateralism. And yet, I think running through this is your own remarks made clear. You think that some people have done some disastrous things with the presidency, and some people have done a better job, if not a perfect job. And a lot of that seems to be more about substance of what the policies were than how they reached those policies. As an example, you criticize the George W. Bush administration, and you have maybe 3 examples of their sins against the National Security Constitution, one of which is torture, one of which is Guantanamo, understand. But a third one is the Iraq War. And yet in the Iraq War, Bush went to Congress. Congress authorized it well before the event happened. Everyone can agree that it was a debacle and a terrible decision, but was that really a violation of the National Security Constitution? Or was that actually the process working like it should and just people making bad decisions within that process? The flip side being, as you talk about in the book, when in 2011 with Libya, with your support and advice, Obama directs the military to participate in a humanitarian intervention without prior congressional authorization in the first instance, stays on beyond the 60-day clock that may or may not have attached to it from the War Powers Resolution, and you offered him legal advice about how that could be portrayed as lawful. But that was executive unilateralism. That was not congressional involvement. But as you just mentioned, it may have saved tens of thousands of lives. And so what is the North Star here? The real root? Is it the process, the National Security Constitution, or is this an overlay for people making the right decisions regardless of the process?
I think the right process is more likely to lead to the right decisions. So, it's a simple constitutional fact that the basic change between the Constitution and what we had before is we don't have a king. That wasn't to say that a wise and noble king wouldn't make the best decisions. It's just that a terrible king would make the worst decisions without any kind of check or oversight. And so they opted for a different kind of structure, which is a system where there's presidential initiative, congressional disposition, and consultation and approval on key issues, and then judicial determination of whether these things are lawful or not. Now, that means that it's a two-key system. You have to get approval from both the Constitution and domestic law and from international law. So, compare the George W. Bush's Iraq War with George H.W. Bush's Operation Desert Storm. There, Bush won, got a UN Security Council resolution to drive Saddam Hussein out of Kuwait, and then got legislative approval to execute up to the level of international law approval. And as a result, the allies were on board because of the UN, and Congress was on board because it was within the scope of their authorization. George W. Bush in Iraq in 2003 essentially didn't get a new Security Council resolution, so no new international approval. He went to Congress and told them that there were weapons of mass destruction, which there weren't, and then they voted one, and then he did an invasion, which I think everybody agrees has led to a disastrous outcome. Now, when you're in the Obama administration, you can't go back. One of the great things about being an academic is you can go back and say, in 2003, we never should have invaded Iraq. But in 2009, you don't go back. You just have to go forward, and you end up trying to bring the situation as it has evolved back to where it should have been if this bad thing had never happened. And people will say, you guys are hypocrites because you're on the exact same path as you were criticizing. And the short answer is we don't have the freedom to change history that way. Now, the Libya intervention, I think, was a different situation. There was a unanimous Security Council resolution, which they got very fast. And then the question was, did the War Powers Resolution, a 60-day clock, was it violated by the intervention? When they committed the troops in the first place, nobody objected. So the only question was, did they have to be withdrawn after 60 days? And I did what the Supreme Court would today call a contextual analysis. It's according to a phrase from this morning, which is quite simply, the War Powers Resolution was a no more Vietnams statute. It wasn't a let's have more Rwanda statute. There was nothing to suggest that Congress thought that if you could stop a potential genocide in more than 60 days, that you shouldn't continue to do so. In fact, Clinton had bombed in Kosovo with 19 NATO countries for 79 days and ended up basically creating a new country, which is part of the United Nations today. So my view was, I could say to Obama, you should treat this 60-day clock as something that applies and forces you to do something which doesn't make sense. Or you could simply do what we did, look at the facts. At that point, there was less than 1% of the ordnance dropped in Libya as we had dropped in Kosovo. And I thought we could conclude fairly that this doesn't rise to the level of hostilities, that doesn't trigger the War Powers Resolution. And we set a series of conditions on this. And in doing so, I was perfectly happy for those conditions to apply to all future interventions by whichever president chooses to do it. Now, it's funny because when I went back to the academy, I got picketed and students boycotted my class, and they wouldn't let me teach human rights. And at one point I said, isn't that amazing? The ACLU favored this, my not being allowed to teach human rights. And I said, you mean the ACLU marches for the rights of, fights for the rights of Nazis to march in Skokie, but it won't let me teach human rights? a law school in which I'm a visiting professor. That seems pretty weird to me. But at the end of the day, the question is, what was the correct outcome? And I think that what we did in all those cases was to follow the rules of international and constitutional law. But that shows you something about the ethical responsibility of lawyers. Put it this way, you could, as a criminal defense lawyer, exercise every ounce of skill and knowledge to get somebody off because they haven't proven their guilt beyond a reasonable doubt. But then you could wonder, as an academic or a scholarly observer, whether that moved the law in the best direction. And part of what I'm doing at this stage of my career is saying, I did my job for my client. I wouldn't do it a different way. But on the other hand, it does raise the question of whether this is why unilateralism persists.
All right, I'm going to ask one more question while he's giving the answer. If people would like to ask him a question, there's a microphone up here. They do not want you to talk just from your seat because they're recording this and live streaming it. So it's up here by this white pillar. Please come up. I was going to say, as sort of an exit, reading the book and knowing you and knowing your career, it was interesting to see how you toggle through this sort of third-person neutral, first-person argumentative, first-person memoir tone. And there's incidents in which you're choosing one of these voices and when you could have chosen another one. And the one that jumped out at me was when you were describing the lawsuit against the Clinton administration in the 90s to vindicate the rights of HIV-positive Haitian refugees at Guantanamo, where the Clinton administration was taking the position the Constitution didn't apply there. The lawyers win a judicial ruling that the Constitution does apply there, but then are put in the position of having to accept vacating that ruling as part of a deal with the government to get their clients brought into the United States. And the sense of doom that hangs over that, knowing that just a few years later, the legal black hole that therefore persists there will be exploited by the Bush administration to bring terrorism detainees and hold them there without legal rights. And you described that simply as something that the lawyers had to do. And because I know you, I know that you were one of those lawyers, along with Michael Ratner. But you chose not to write that part as a memoir. I was wondering, how did you make that decision? And is this something, this kind of hands-on work that you've done, something you may revisit as well as your next project or down the road?
You mean my next book, at which I hope to have a session here at Politics and Prose? Yeah, I'm happy to discuss that. Well, the case you mentioned is a very dramatic one. We represented Haitian refugees on Guantanamo. At one point, as many as 80,000. And we were fighting for their rights to be recognized as persons who had rights under the Due Process Clause. And the U.S. government's position, first under George H.W. Bush and then Bill Clinton, was that they didn't have any constitutional rights. Even though, as Justice Souter pointed out later in the Guantanamo case, iguanas have legal rights on Guantanamo, but not human beings. Now, we ended up winning at trial a permanent injunction in which the ruling was that they had due process rights. And then the Clinton administration came in, and Webb Hubbell, who is President Clinton's friend, was Deputy Attorney General, and they called and they said, we don't want to appeal, but we will bring in the 220 Haitians on Guantanamo if you agree that the settlement be vacated. And, it occurred to me, this is the only ruling that we have that human beings on Guantanamo have due process rights. If we let it be vacated, they could bring other aliens there and hold them forever, which is frankly what's been going on. I mean, as you well know, Charlie, from your own work, this opened the door. Getting these 220 people out opened the door to Guantanamo being now entering its 21st year as a Al-Qaeda detention center. So that was a direct product of this decision that we made on behalf of our clients. The other thing I thought was, if this leads to the elimination of asylum for mass outflows, we could have a situation where even democratic administrations essentially eliminate the right to asylum. And I think that's very close to where we're at right now, only a couple decades later. So, you make these decisions and they have certain kinds of consequences, and it's very painful. But that just means that lawyers have to make ethical choices, and that was what the book was trying to do. Now, by the way, I decided deliberately not to make that part of it a memoir. I thought it should be kind of so the first part of the book is history, as if I'm a constitutional historian. Starting in the Reagan administration, I was involved in almost every single issue I discuss. And so that has kind of a first-person dimension. But my next project is going to be a book called Lawyering Beyond Borders, where I'm going to tell the story about how do you be an international lawyer. When I was a student, college student, I wanted to be an international lawyer, and no one could tell me what you did. And what I think I'm going to do, or I'm starting to do it, is to have a chapter about a variety of different experiences, arguing at the International Court of Justice, arguing at the U.S. Supreme Court. Kurt Campbell is here getting a blind Chinese activist out of the embassy in Beijing, and how a lawyer thinks on the fly. And so it'll be partly memoir, but more it's about how you can be an international lawyer even if you never appear in a courtroom. And I'm hoping that, well, let me put it this way. When I wrote this book, I thought, if a student who's interested in this area says, how did this get here? How did we get to where we are, and what should we do about it? You could just hand them this book and say, this guy is long gone, but this is what he thought. And he was probably in a unique position to know. The book that I hope to do, and I'm a couple chapters in, will be, I really would love to be an international lawyer, but what exactly is it that international lawyers do? And here's the book, and it's got 13 chapters, and each one tells you about how to do this, how to do that. And then you read and you say, okay, that sounds too arduous. I'm not going to do that. I'll go off and be a rock promoter or something like that. Then I would have made somebody's life better.
Okay. Sir, please, talk into the microphone.
Is this close enough? Just as an aside, I'm finishing my history PhD, so I'd like to say I have a lot of respect for scholars who are willing to make claims about the very recent past, something which everybody in this room is going to claim that they're an expert of. As a historian, I get to hide kind of behind the shield of time, if you will. But since you are making claims about the recent past and offering prescriptions, I'd like to ask you your thoughts in terms of what Congress's role should be in the national security state in a more grassroots way, because I have a background in military building and development. Congress can and has passed laws and guidances intending to constrain the negative effects of executive action, basically. But in day-to-day work, if you're a state or a defense bureaucrat, no offense to state or defense bureaucrats in the room, it's very easy to, or if you're a defense attaché in Sri Lanka, it's relatively easy to avoid a lot of those restrictions. So is there any role that you see, if any, that Congress can play in terms of the administration of national security and not just the legislative design of it?
Yeah, good question. So first of all, a critical point about this book is it's not just about personalities. If the problem were personalities, you just throw the rascals out. What we see is you can throw some rascals out and they can come back. But the problem is that the problems are structural. They affect people who are in these jobs and in these branches. And so part of it's the synergistic, dysfunctional interaction of these three branches of government that creates this continuing trend toward unilateral action. So, just to take it, would the Biden administration, if reelected, get dragged into a wider war in the Middle East in which we're helping to fight Hamas, Hezbollah, Iran, and the Houthis all at the same time because we're trying to support Netanyahu and do other kinds of things? And what's happening is that our constitutional tools favor use of force and disfavor diplomatic outcomes, which make it harder for us to enter into the kinds of enduring deals that we're going to need to get to peaceful outcomes in, say, Ukraine or Gaza. Now, Congress has been particularly disabled in this area because they are so disorganized. And a question is, there was a time when you had people like J. William Fulbright and Vanderbilt who were senators who had expertise, and then they were easy candidates to be the next Secretary of State. And a question is, why do we let foreign policy in Congress be so politicized? We have a Joint Committee on Taxation, which is a bipartisan expert group that addresses technical questions of taxation and in a way that with an expert staff, and they're universally respected. So why don't we agree to such a thing on national security? Or put another way, why on earth should Marjorie Taylor Greene or Matt Gaetz have some kind of veto with regard to foreign policy, which are things that A, they know little or nothing about, and B, seem to have absolutely no interest in addressing in a way that best serves the foreign policy interests of the United States? A second question is, why don't we have a congressional legal advisor? If the executive branch issues an interpretation like the one we did in Libya, if they disagree, they can challenge it. And then we have a competing debate over that, of the kind that happened, for example, about reinterpretation of the ABM treaty. And then third, Congress lost the legislative veto and never replaced it. Why don't we have a set of tools connected to, for example, fast-track legislative procedures and appropriations, which allow there to be specific approval for particular kinds of actions? So if, for example, President Biden sees the need to conduct repeated military operations against those who are attacking Navy vessels, the Houthis, why not get a targeted, specific legislative enactment that's put on a fast track like in trade, where it doesn't get amended and gets brought up for an up or down vote in a quick period of time, and set some limits on what Biden can do? Then he's on a stronger footing, and Congress is engaged, and there's an incentive to keep them informed and consulting with them. So a lot of this book is each branch of government, I try to address what they could do so that they can play their role better. And my goal is not to weaken the president, it's to have a strong president within a strong constitutional system. Thank you.
What if Biden gets dragged into a war before the election? And I was wondering if the U.S. Officials were worried about ICC or ICJ, and why don't we become a member of that? And the Assange plea bargain got kind of drowned out by the disaster debate, and I'm hoping there's a third option. Maybe Chris Coons could negotiate with the Democratic committee and get control of the campaign funds and get better odds.
Let me pull one of those things out. Why don't you talk to us about the role of the ICC and Democratic administrations in particular, ambivalent relation to it, and what you see is happening here?
Well, Ambassador Van Schok is here. That's her day-to-day job. But I support her in her mission, which is international criminal adjudication and prosecution can and should be an important part of what American foreign policy does. We don't have a better solution for many gross violations of international law than to be using international adjudication. We supported Nuremberg. And we had prosecutors at Nuremberg, Justice Jackson, Senator Tom Dodd. What we need to have is a policy where we weigh the costs and benefits of these over time. So you have somebody like your friend Lindsey Graham, who, well, I'm kidding, but they've traveled together productively. And the net result is Lindsey Graham saw the wisdom of working with the prosecutor's office on Russia for Ukraine with regard to the unique violation of child stealing, which ought to be a gross violation in any case. And then suddenly, because there's a reference made on Israel, they decide that it's the worst institution in the world and we should just break all relations with it. I mean, we need a policy, something that's nuanced over time, that sets when we're supportive and when we are expressing concern. And also people need to understand what these timetables are. They didn't indict Netanyahu. A request was made for an arrest warrant that has to come up before a pretrial chamber, which is exercising a reasonable grounds for prosecution standard. And we don't know how that's going to turn out. So instead of coming down and saying that the ICC ought to be defunded or that we're imposing sanctions on them, we need to decide what situations the ICC is going to help U.S. foreign policy to achieve its intended outcomes. Now, fortunately, we have an ambassador at large for war crimes who understands all of this, and I think is doing her level best, I'm sure, to try to make sure that these points are being made both within the executive branch and also with members of Congress.
I think we have time for one more question.
Good evening, Michael Cooper from the American Society of International Law. Harold, I had the privilege of hearing you speak earlier today, so I, in all transparency, feel like a bit of a plant. I'm going to ask you to cover some ground that you covered quite eloquently earlier today. Earlier today, you spoke about the way in which space and time can sort of shift your view of the law, that your view of a particular complex issue of international law can evolve over time, but can also evolve in space from the position from which you view the law, the role that you're playing when you look at that particular issue. And I wonder if you could talk about that more, because I found that quite interesting.
Yeah, you can. Lawyers can have a relationship to a particular body of law that extends across their career. Nobody expects a prosecutor's view of criminal law, a defense lawyer's view of the exact same body of criminal law, and a judge's view and a professor's view to be exactly the same. Depending on what role you are in, you're going to view the same body of law from a slightly different perspective, which is one reason why I've been lucky to have many different perspectives, because when I returned to the academy, then I asked the question, what is the best outcome from all of these different vantage points? What is the Archimedean center? Which may mean that you do something or recommend something to your client if they want to do it and it's lawful, that in fact you might think as a neutral observer was not the best thing that could have happened in the world. But that's sort of where you are. It was very interesting, the Libya intervention. What almost nobody focused on was that John Kerry, Nancy Pelosi, Harry Reid, John Boehner, and Mitch McConnell, to some degree, all agreed that there was no violation of the War Powers Resolution. That, to me, is congressional acquiescence, and I think Obama was entitled to rely on that. And we were able to say to Obama, given that, we think you can say this is a reasonable interpretation of the War Powers Resolution. I think we could also say to Congress, maybe it's time for you to pass a new War Powers Resolution rather than relying on one that has been clearly outmoded in terms of its terminology and application. But again, Congress was active in 1947 in the National Security Act. He was active in the late 70s and 80s, after Watergate in Vietnam, after the Iran-Contra affair, nothing. After Trump, close to nothing. And this is where we are. And part of what I'm trying to do in this book is say, Washington, we have a problem. The problem is structural. It requires structural solutions. And I've suggested a whole bunch of these structural solutions. Some of it's directed to congressional staffers, some of it's directed toward incoming executive officials. If you really want to address this issue, don't say there aren't any ideas. There are ideas. The question is, are we Americans first? Will we return to a view of politics where we're Americans first and stop talking about America first and actually collaborate on a bipartisan basis to make this a better world for our next generations?
I'm going to squeeze in one more question. Karen, were you wanting to say something? Karen DeYoung? Kate, sorry.
Yes, thank you. So, Harold, I was wondering if you could just talk about how the role of the courts and the effort to promote protection of human rights globally, not just in the United States, has changed and what you think about all that. When we started out, we used the courts to protect human rights and civil liberties. It seems to me that one of the problems with talking about, well, the result turns out well, is that you end up with a Supreme Court filled with justices going, we'll argue however we want because this is the right result. And that lots of people view it as that's what's happening. And that the division between human rights and national security, which you didn't subscribe to, I don't think, in your career, but still exists in the way we talk about it. And I wonder if your suggestions cover how we can come to understand that protecting human rights for everyone is going to be essential to everyone's security, assuming you agree with that.
Well, I think our current Supreme Court denigrates rights, but the way that it does it is by professing to apply certain kinds of threshold standards that allows it never to get to the adjudication of gross violations of rights. Among them was the presumption against extraterritoriality. Why do we have a presumption against extraterritoriality in the Refugee Convention? Refugee conventions, refugees cross borders. Why would Congress have legislated about that with a presumption against extraterritoriality? Or pirates, pirates are extraterritorial. Since when would Congress legislate with regard to pirates with a presumption against extraterritoriality? But what the justices do, and particularly Chief Justice Roberts is very skilled at this, is to suddenly invoke some threshold test, the classic now being the major questions doctrine. So we saw this today. The Supreme Court can simply designate something as a major question and then deeply intervene and ignore administrative agency expertise. But in other areas, it can choose to be extremely deferential because of foreign affairs. And to me, it's very ironic that one of the cases in which they exercise this super micromanagement is the West Virginia EPA case, which is actually a foreign affairs case. It's a climate change case. So if you're applying this doctrine in a neutral way, you would have said that they should be deferring to what the EPA did to try to implement the Paris Climate Agreement. So to this day, we still don't understand what their criteria are for flipping on the major questions doctrine or flipping it off. But the net result is that people's rights are not being protected because of these claims of canons of deference, presumptions against deference, et cetera.
All right. Harold, thank you very much for writing this book and sharing your thoughts with us tonight. Thank you, everyone, for coming out. Everyone should buy 6 or 7 copies. And he'll be